We continue now with our lecture on informed consent, Part B. The moral requirement to obtain informed consent is firmly grounded in the principle of respect for persons or respect for autonomy. You can't be respectful of someone's autonomy if you don't respect their right to make decisions about their own lives for themselves. And the Nazi experiments were a very clear example of moral wrongs in research, and they showed how badly things can go wrong in situations in which people do not give consent for the research that they participate in. And it's just as much a violation of a patient's autonomy or a patient's dignity to treat them or to perform procedures on them as patients without their prior permission. Informed consent. Now, in bioethics, very often when you hear the word consent, it is almost always paired with the adjective informed. We might ask ourselves why. Well, it's fairly obvious, really, and that is because you can't truly give permission to someone to do something to you if you don't fully understand what that something entails. So, to give consent to something, you must first know why you need to do that something at all, what that something actually entails, what the consequences of that something could be, and what the risks and benefits associated with doing that thing are. We also often speak not just about informed consent, but about valid informed consent. Now, it's important to note that informed consent is not just about getting a document signed, nor is it just about some kind of verbal agreement. It is a process, and it's a process in which patient autonomy needs to be respected, and it's a process which is designed and intended to promote trust. In both ethical and legal terms, a valid informed consent has to have 4 elements. We speak of those 4 elements as firstly, full disclosure, 2, understanding and appreciation, 3, voluntariness, and 4, capacity. Now, before we have a look at those elements more closely, it's important that we establish something right up front in South African law. Right back in 1923, in a very famous court case, Stoffberg versus Elliott, there was a ruling which established very clearly that in South Africa, tacit consent or assumed consent is not acceptable. It has to be expressly obtained. What happened was Stoffberg woke up after surgery for cancer of the penis to find that his penis had actually been completely removed. The doctor apparently was a visiting surgeon, and he had simply assumed that consent had been given for the operation when in fact it had not. In the case, the judge ruled that a man, by entering a hospital, does not submit himself to such surgical treatment as the doctors in attendance upon him think necessary. By going into hospital, he does not waive or give up his right of absolute security of the person. He still has the right to say what operation he will submit to, unless his consent to an operation is expressly obtained. Any operation performed upon him without his consent is an unlawful interference with his right of security and control of his own body. What this implies is that the law does not allow for tacit consent, and it does not allow for assumed consent. Consent has to be actually expressed. This is supported also by the Health Professionals Council's booklet on informed consent, which states that consent must be expressed by a patient verbally or in writing. Written informed consent is also required for all research. Okay, we look now at the first of the elements of informed consent, and that is full disclosure. In research, full disclosure means a number of things. It means that study potential participants must be made aware of the purpose of the study, the nature, the duration, and the type of study. They must be made aware of the risks and benefits, and this must be explained to them comprehensively and clearly. They must be aware of any compensation or reimbursement that will be available to participants should anything go wrong. They need to know whether there will be access to treatment or interventions for those who have participated at the end of the study. They need to be assured about confidentiality and how it will be protected, and this includes issues around the security of records. And they need to know whether anything will be disclosed and to whom disclosure will be made. Furthermore, they need to be told about whether or not there would be compensation. In case of death or injury, they need to have their legal rights explained to them. And participants need to be told of whether the research findings after the study has been completed. They need to be given details of the investigators and of their qualifications, and they also need to be given information about the Ethics Review Committee or the Research Ethics Committee that approves the study. In some contexts, when we're talking about research, it may also be necessary to involve not just participants, but also their communities. And in Africa, with its strong communitarian values, community-informed consent is often also required. Now, this could begin with first consulting with the community about the planned research, even before a protocol has even been agreed. Full disclosure in clinical practice, here a patient needs all relevant information to be given to them for them to be able to give proper informed consent. Now, this is supported, interestingly, in South African law because the National Health Act requires all health care providers to obtain informed consent before proceeding with treatment. The National Health Act specifically requires healthcare practitioners to advise on the patient's health status, unless there's substantive reason to believe that telling the patient their status will be harmful to them. It also requires that healthcare practitioners explain the full range of diagnostic and treatment options available. So it's not just a matter of offering one kind of treatment. If other alternatives are available, they should be offered as well. It requires that the healthcare practitioner advise on the benefits, the risks, the costs and the consequences of each option. And it establishes very clearly that the patient has a right to refuse treatment. And when they do, it is necessary also to explain to the patient the implications, the risks, and obligations of that refusal. Looking more deeply into this, the benefits of each treatment option, well, this implies a requirement to inform patients that there are other treatment options available. And the ethical pitfalls to avoid here are offering patient only the most expensive option or overselling benefits or making claims that can't be substantiated. We also have to explain the risk of each treatment option. Now, it's important to note that all foreseeable medical side effects are risks. But the legal requirement is that healthcare practitioners must disclose material risks to the patient. Not all risks, only material risks. So we might well ask ourselves, well, what is a material risk? Now, in the old days, that used to be decided on what was based what used to be based on what was known as the professional community standard, and that is that it would have said, well, a material risk would be anything that other healthcare professionals in the same field would regard as a material risk. These days in our law, that has changed, and we now speak about the reasonable patient standard, a patient-centered approach. What does that mean? Well, according to this standard, a risk is material if a reasonable person in the patient's position, if they would be warned of that risk, would attach significance to it. The healthcare practitioner needs to be reasonably aware that the patient, if they were warned of the risk, would attach significance to it. In other words, what counts is whether or not the patient would see it as significant. Every possible complication does not need to be disclosed, only those that the patient would likely regard as material. Also have to consider the risks of every treatment option on the basis of case law, and that establishes that the kinds of risks that need to be disclosed are common risks and serious risks, even when the chance of a serious risk is low. So if it's a serious risk, it must be disclosed. As a guideline in our case law in Lawrence versus Olvaga in 2006, the court ruled that a 2% risk is negligible and there is no duty to disclose a negligible risk. What that suggests is that more than 2% as a chance is not negligible. But the seriousness of the risk must be considered as well. The costs of each treatment option. Now, it's unusual to specify the costs of treatment as part of the necessary disclosure for informed consent. Nonetheless, that is the truth in South African law. I guess it makes sense. A patient has a right to know what treatment will cost before consenting to it. But it's important to note that in South Africa, it is actually a legal requirement. Where a course of treatment is recommended, the costs of the whole course need to be explained to the patient, not just the first consultation or the treatment. That is, an estimate needs to be given of the cost of the whole duration of the treatment. Regarding consequences of each treatment option, this refers to any other foreseeable consequences other than the benefits, risks, or costs. So, for instance, it might be important to mention any social stigma that might be associated with a particular treatment. Consider, for instance, the loss of hair that a patient might experience after chemotherapy. It includes things such as how much recovery time is necessary after therapy, when a person will be able to return to work or drive a car. All of those consequences, significant consequences, ought to be explained. That brings us to the end of Part B of this lecture on informed consent.